Before this hearing even begins, you need to understand, this is not a simple courtroom moment. This case is built on allegations of continuous family violence, a mother fighting for her future, and a judge who refuses to sugarcoat anything. Annabelle Bishop stands accused of assaulting her children's grandfather, all while CPS battles unfold in the background. The lawyer wants deferred adjudication. The state wants 5 years. And trust me, tensions explode fast. Watch closely, because every answer, hesitation, and facial expression in this hearing matters. Let's see how it unfolds.
All right, could I have the parties on Annabelle Bishop?
Good morning, Your Honor.
Good morning. All right, the court is going to call 2023 CR 2077, State of Texas versus Annabelle Bishop. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense.
Thomas Siller for the defendant.
Are you Annabelle Bishop?
Yes, ma'am.
You entered a plea on May 1st. According to the plea bargain agreement, and it's a continuous violence case, the state is silent on your application, but they're asking that punishment be assessed at 5 years in the prison. Have parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No, Your Honor. I just have one witness, Your Honor.
All right.
From the state.
Thank you. You may call your.
At this early point, both the defense and prosecution say they have no objections to the PSI report, and that's big. When neither side objects, it usually means the facts inside the report are solid, agreed upon, and will heavily influence sentencing. Watch closely now. The defense is calling the mother as their only witness. That tells us the entire emotional appeal of their case rests on one person, and her credibility is about to become crucial.
You may call your witness.
Ms. Bishop.
The mother. Yes.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear and I can hear. All right, can you state your name for the record?
Anna Bishop.
All right. Defense?
Please state your name, the relationship to Ms.
I'm
Bishop.
her mother.
At this point, you understand the charges against this court, pending in this court?
Yes,
Do you know the dynamics of the ex-husband and his father?
Yes, I do.
Okay. And at this point, they are wanting her to go away for 5 years.
Of course they do.
And at this, can you please tell the court what are your wishes as to your daughter?
I don't think that she should go.
This moment is key. The mother isn't just supporting her daughter. She's begging the court to give Annabelle a second chance through deferred adjudication. But notice something. Instead of addressing the violence directly, she shifts focus to substance abuse and mental health. Judges pay very close attention to this. When a parent avoids discussing the core behavior, it can signal denial, and that denial becomes a problem in sentencing.
For 5 years.
Do you ask this court to grant her deferred adjudication?
I plead with this court to grant her. Defer.
At this point, the court prepared, or the court says there's no mental health issues. And what kind of needs do you think your daughter has if given probation today, substance abuse wise?
Yes, that she be placed in a program and
Outpatient, that is?
outpatient, please.
Is it, what kind of drugs is she using?
To my knowledge, and for CPS, it's weed.
And other than that, what other, does she need any kind of additional mental health services? Anything? What
I
else does
believe
she?
that she might, yes.
I know that nothing was identified officially, but what makes you think?
Nothing was identified because no one's taken the time to actually,
But what are your
counsel her.
concerns with her?
All right, you all need to talk one at a time.
What are your concerns with your daughter?
My concerns are that she just needs the help that she needs. And she doesn't need to go to.
Here the defense is trying to show remorse, but the PSI report says the opposite, that Annabelle shows no remorse. That contradiction is huge. Judges hate inconsistency more than anything. The mother insists her daughter is remorseful, yet the official report shows otherwise. This kind of disconnect can completely destroy a defense strategy because the court starts questioning who's being truthful and who's just trying to save a loved one.
Go to prison. I think that she would be able to do this out.
Is it your first felony, of course?
Yes, her first.
And
Yes.
who else lives in the household with you?
Just me.
You spend a lot of money and effort to get her on bond. How much money did you spend on that?
$2,500
Okay, and then she's back in jail. Why is that? Why is she back in jail?
because she missed her court date.
And other than that, she was always a good, well behaved.
Yes, and she only missed her court date because she had a scratch in her eye. And she does have medical records for that.
Okay, and at this point, do you think she will be able to successfully comply with the education requirements, going to classes, making appointments, reporting, staying away from the alleged victim?
Yes.
Okay, and it says here that she has shown no remorse. She thinks it's all fun and games what she did to the ex-father-in-law. What do you think? Do you think she's remorseful?
Yes, I do. And they should be remorseful for what
I
they
was
did
saying
to her.
she took responsibility for what she's charged with. She's not saying she's innocent, but she's remorseful, you're saying?
Yes. I am.
And she understands,
It's remorse.
and she understands, and you understand, if the court was to give her on her first felony, the first education, if she messes up, she'll get the full individual punishment and go to prison for much longer. She understands that, you understand that?
I understand.
Okay.
You would need to ask her.
But the other high school diploma, she understands everything. She's competent, you believe?
Yes, sir.
Okay. And at this point, again, I was trying to clarify with you. Does she need mental health evaluation, you think?
Yes,
If-
I do.
On what basis?
On the basis that I've been her mother for the last 25 years and I know my daughter, and she's changed a lot ever since she met her husband. And she's just mentally been abused by that family. That's what I'm basing it on.
What kind of service does she need? Counseling? Does she need evaluation? What does she need?
I would think that she would need counseling and psychiatric evaluation.
But all that can be done outpatient. You're asking for the court to grant or deferred. So
This is a powerful and emotional exchange. The mother claims her daughter has suffered years of mental abuse from her ex's family, but the judge is laser-focused on evidence, not emotion. Notice how the judge keeps asking, based on what? Emotional claims without documentation rarely influence sentencing. This is a classic courtroom moment where personal pain collides with legal standards, and legal standards almost always win.
These are today.
Yes, I am. I'm pleading.
As a witness, thank you.
Any questions?
No questions.
All right, I have some questions. So you're her mother?
Yes,
How many children does she have?
she has two.
All right. Why was CPS involved?
Because her father-in-law called CPS.
Okay. And the grandchildren were placed with the father-in-law, correct?
They were placed with the father-in-law and the non-biological grandmother.
Okay. So that's where the children were placed.
Yes, ma'am.
All right. Are you aware of the facts of this case?
Not all the facts.
Are you aware that she gave him a black eye?
No.
Are you aware that she went over to the home? At the job site, it states, the victim said that his grandchildren were placed on a safety plan on Tuesday, January 3rd, 2023 by Child Protective Services due to physical abuse allegations. Do you know what that means?
Yes, we do.
All right. So what that means is that Child Protective Services didn't do a legal case, and her attorney will tell you this. They just did a safety plan. So the safety plan is designed to get the parents stabilized So what they did was they placed the children with the father-in-law, and I'm sure they told her that these are the times that you can have your children as far as visitation. So what he says is around 9 a.m. today, the defendant, your daughter, came to his job site again, banging on the door. His coworker alerted him that she was here, and they called the police. The grandfather came through the gates and told her to leave. She began yelling, "Where are my effing kids?" He grabbed her phone and threw it so that she would leave the property. She then punched him in the face a couple of times and ran to get her phone. Shortly after, she returned on the property, threatening to damage the grandfather's truck and flatten his tires. She was looking for rocks, so he went to stop her. She came at him swinging with a closed fist. He grabbed her by the shirt and hip tossed her to the ground. He placed his hand on her back until she calmed down. That's what happened. And that was on the first occasion, because this is continuous.
The judge lays out the incident in full detail, and it's brutal. Punching, threats, property damage, aggression. This is exactly what continuous violence cases look like when they escalate. The judge is establishing a pattern, not a one-time mistake. And when judges see patterns, deferred adjudication becomes nearly impossible. Pay attention here, the judge is not just recounting facts. She is building the backbone of her sentencing decision.
And it says that your daughter has a drug problem. Does your daughter have a drug problem?
Yes.
That's either yes or no. So what drugs are she using?
To my knowledge, marijuana.
So you think she's only using marijuana? And you think all of this, that Child Protective Services, which they don't even do anymore, I don't know why they don't do it, but Child Protective Services are not putting children in safety plans or removing them because parents are using marijuana. It has to be more than that. Do you understand?
They didn't tell me that.
Okay.
I actually.
All right. So as a parent, sometimes we let our love of our children blind us or look at things through rose-colored glasses. In order to help children, you need to take the rose-colored glasses off and see your child for who they are. Now, you may not like what you're seeing with your child. You may not like the relationships they're choosing. You may not like the fact that they're doing drugs, but you have to acknowledge that and quit glossing over the fact that she doesn't have custody of her kids. And I hate kids because it's baby goats, but I'm saying kids with the cuts. That's what's in the police report. But she doesn't have custody of her children. And the reason why she doesn't have custody of her children is because there's allegations of physical abuse, not physical abuse where her partner that she chose is hitting on her, but physical abuse to the children and drug use. That's why there was a safety plan. And that's why the children were placed with the grandfather. Now, why the children are not placed with you, I don't know. Maybe it's because you're not acknowledging the fact that your daughter has violence issues, that your daughter has drug issues. Maybe that's why the children didn't place them with, maybe that's why CPS didn't place the children with you. I don't know if you had a chance to put your name down for somebody to be.
This is where everything shifts. The judge essentially calls out the mother for being in denial, explaining how parental love can blind someone to serious issues. This is one of the harshest yet most honest moments in the entire hearing. Judges rarely speak this bluntly unless they believe denial is enabling dangerous behavior. She's making it clear. Ignoring violence and drug use is exactly why CPS didn't place the kids with the mother either.
He interviewed.
Yes, I did. And
Yeah.
I don't mean to interrupt you, but they came to my house, and because I was working, she said that I was too busy. And I've been trying to get a hold of them. I've been trying to be part of the safety plan, and they've been pushing me away.
Well, I mean, if they are pushing you away, I do, honestly, I understand why. Because you think that your daughter needs to be on outpatient treatment. You think your daughter needs to be released, and you're not looking at the fact that the children are in the care of this grandfather.
This grandfather.
Because of allegations of physical abuse, and because she is living with somebody in a vehicle, do you really think it's great for children to be living with parents living in a vehicle?
Your Honor, may I speak?
Yes, you may.
Okay, John Tovar and Jacob Tovar started Annabelle on drugs.
Mhm.
They gave her the drugs.
And how old was she when this started?
18,
All right. And how old was Tovar, her boyfriend?
19.
And where were you as a parent? Were you letting her be out and about? Was she still living with
She
you?
was married with her husband.
These are choices that people make. And what drugs were they using? Just marijuana?
To my knowledge, like I said, I didn't.
All right. So you're saying he started her on marijuana. So according to you, the only drug that she's ever been using has been marijuana. Is that what you're telling the court?
To my knowledge and what I know, yes, and what she's told me.
Okay. All right. Thank you.
Your Honor, with that, I have no further questions. And I pass.
Any
the witness
questions?
And I rest. No questions, Your Honor. Just argument.
All right. Thank you so much for coming in to give me an insight into your daughter. I appreciate it. Thank you. All right. Anyone else you want to call?
I rest. Just argument.
All right. The court will hear argument.
Respectfully, my client is remorseful. She does have a place. She has a family support system. She's denying mental health, but the mother thinks she may need some kind of relation. And as to substance abuse, I understand we do have some recommendations, big UAs for the first 90 days. But because it's really her first felony conduct, we're asking the court to defer finding of guilt and give her a chance to either show the court she needs help, she will benefit from help, she will seek help, and the court has lots of help available to her. And if not, she will hang herself. Thank you.
All right. Anything you wish to say to the court?
I do.
You want to raise your right hand?
Yes,
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right. You can lower your hand, state your name for the record.
Annabelle Bishop.
All right. What do you wish to say?
I am very remorseful for what happened that day. And I don't feel like I should be,
What happened that day?
well, you had just explained it, but that wasn't the whole story because he did put his hands on me as well, numerous times. That's why I pressed charges back on him.
Why were you at the location?
To retrieve my kids.
All right,
Because
and
the original agreement was my kids were supposed to spend the night with him and I was supposed to pick them up that morning.
No.
That's why I was there.
So you're saying there was not a CPS safety plan in
Oh,
place?
yes, there is. Mhm.
All right.
And the plan that me and Jacob had came up with was for his dad to be on the plan and my mom to be on the plan.
Just please, I'm sorry. I just want to just guide you.
No. I want to listen to what she's saying because she's changing her story to me.
Well, may I have a minute?
Now Annabelle takes the stand, and instantly her story begins shifting. First she says one thing, then backtracks when the judge confronts her with conflicting statements. This is deadly in a courtroom. When a defendant appears inconsistent, it erodes trust, and trust is everything during sentencing. The judge is noticing every contradiction, especially around the safety plan and the children. This moment practically seals her fate.
No,
Thank you.
she's on the witness stand. So go forward.
But anyways, I'm very remorseful for what happened that day.
No. Let's go back to the safety plan business.
Yes,
So you're saying there was an agreement with the safety plan for what?
just for my mom and his dad to be on the safety plan. That's it. That's all I was gonna say.
No, your mom just testified. You heard her testify that says she was not considered for the safety plan. So she was not on a safety plan. So your mom wasn't on there. So the only person who was on the safety plan was him. So why did you think that you were to go and pick up the children?
My kids,
Yes.
because I missed my kids and I just wanted to see my kids. That's the only reason. I love my children.
Did you realize that was a violation of the safety plan?
No, I didn't realize that.
All right, you want some questions?
Oh, you want to just vaguely.
Sure.
You're not minimizing your involvement. No, you're still taking full responsibility.
Yes.
You're asking the court to not send you to TDC today. You want help for substance abuse and maybe mental health if identified.
Correct.
And you understand deferred, if you mess up, you get the full range of punishment.
Yes, I understand.
And this could be more than 5 years.
Yeah.
Okay. And you want to stay away from the complaining witness,
Yes,
from the families, and you're going to comply with all safety plan, court rules, anything.
Whatever it takes.
And your mother, who else lives in the household?
Just me and my mom. That's it.
And she has to spend a lot of money to bond you out,
Yeah.
and you missed court again. Why? Because you were
I had a corneal abrasion in my eye.
okay, and you provide documentation of that to the
Yes,
court.
sir.
Okay, thank you.
What drugs were you taking?
I've only ever done marijuana. That's it.
Okay. All right. Is there anything else?
Oh, you guys.
All right. Court is going to find you guilty. The court is going to sentence you to 4 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Jacob Tovar and Juan Tovar. I see that there is a request for restitution, but in the PS report, the court does not have a restitution amount, so the court is not going to order restitution. It's not in the PSI report.
Please don't do this. Why are you doing this?
All right. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with did you understand? Did you sign it?
I thought it was gonna be probation, so I don't know.
All right, because this is a plea bargaining agreement, because I followed the plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to your attorney. And the state has tendered a dismissal for the assault on a public servant. So that case is dismissed. All right, good luck to you.
Your Honor, one thing further, we do have victim impact.
I don't think you want to hear victim impact statement today.
Oh, he's not here.
Thank you.
He said he's not going to show up.
All right, thank you.
And there it is, the final ruling. Annabelle Bishop is sentenced to 4 years in prison, with an affirmative finding of family violence and strict no-contact orders. In the end, the judge determined that the violence, the CPS safety plan violations, and the inconsistencies in testimony outweighed any chance of deferred adjudication. This case highlights how crucial honesty, accountability, and documented evidence truly are in family violence proceedings. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.